thank you to everyone who's attending today. Hopefully there will be some time at the end for questions should you have them. If the kind of urge strikes in relation to anything, I think there is a Q&A function, and if you use that, we'll do our best to pick up on anything coming through. Suppose by way of augmenting Stuart's introduction of Callum and me, we act for a great volume, great diversity of clients in the vulnerable, injured, and disabled space. The team in Glasgow has what I would probably consider to be fairly uncommon experience in dealing with trusts for vulnerable, injured, and disabled people, but also alongside these issues of capacity and other forms of vulnerability that we'll come to as part of the context for the talk today. What we'll cover is we'll start by having an out loud think about capacity and vulnerability and disability and what these terms mean, and their importance in terms of their centrality to planning for the adults and potentially the children who have these issues, but also for their wider family, and putting in place the right types of support structures and trusts as part of that support structure. As part of that wider consideration, there are sub-considerations, if you like, relating to the care needs of people, the benefits entitlements, the support entitlements of beneficiaries of trusts, and the tax implications that arise consequent to the types of trust structures chosen and utilised by the beneficiaries of trusts and by the settlers of trusts, and what it takes to get those trusts right. So what should we be thinking about with half an eye looking further down the line and taking into account our own experience and indeed I imagine the experience that some of you will have had about where trusts can go wrong, and what should we be thinking about at the outset to try and mitigate the risk of trusts going wrong. And then we'll try to pull that together at the end concerning what the key questions should be around planning for trusts of this type and for supported persons of this type. So if we start with a little bit of consideration of this word capacity and the legal definition of capacity, and it's the section 6 or section 1.6 rather definition of incapacity in terms of the current leading piece of legislation in Scotland, the Adults with Incapacity Scotland Act, that we've presented on the slide that you should be able to see. Now, I'm going to start with the very bottom line and note that it is potentially an important consideration. But capacity is potentially only one category of vulnerability, and I was fortunate enough to attend a presentation by Adrian Ward and Sarah Prentice of the Scottish Social Services Council recently, and one of the leading aspects or central pillars of that presentation was Mr. Ward's view that we should move away somewhat from capacity as being central to planning and protection. Protection, I think, is probably the kind of central word. That capacity is important, but there are cultural and religious and social and physical aspects to vulnerability that can go beyond capacity. And for those of us who act in the personal injury trust sphere, and I know that there are a few who signed up today, it can be something of a frustration when we're dealing with matters going through court process and considering the necessity of trust planning, that the view that the court takes tends to focus very much on capacity. And And by extension or by implication, these other vulnerabilities are if they're considered at all, very much considered as second fiddle to that issue of capacity. But I don't want to get on my soapbox too much about that. It's an evolving area in academics around this area of law that is due for reform itself, and indeed the talk seems to be that the Amendment Act, the Adult Incapacity Amendment Act, could be the bill could be with us as early as before the summer recess this year. So coming back to the definition of incapacity, adult means a person who's attained 16 years of age, and incapable means incapable of acting or making decisions or communicating decisions or understanding decisions or retaining the memory of decisions. And that factors into by reason of mental disorder or inability to communicate. And incapacity should be construed accordingly. Now, I've focused in, I think, on this word "or," very much my emphasis. But when we talk about whether somebody has capacity or not, it's not an accumulative test. Incapacity can be demonstrated. It can be established by somebody falling short in relation to only one of those matters, A through E. And a continuation of the question of what is capacity? Well, capacity should be considered to be and is task specific, easy for me to say. A person can be capable and incapable at the same time in relation to their executive function. A fairly straightforward example might be that an adult may be capable of granting a fairly simplified power of attorney because they have the capacity to understand that what they are doing is providing another person with the power to intervene on their behalf. But they might not have the capacity to grant a very complex and lengthy power of attorney going into great and deep detail on specific powers. So that person can simultaneously have the capacity to grant a fairly simplistic document, to have that execute that themselves, or indeed have it executed on their behalf, but not to do so in relation to something more complex that may just be beyond them. And capacity can fluctuate, so that same person can be capable and incapable on different days in relation to the same thing, to the same exercise of their executive function. That makes our life potentially quite difficult in this sphere. Callum and I have acted in circumstances where at the outset of our instruction somebody was incapable of granting powers of attorney, and the guardianship procedure has been advanced, and then in the midst of that guardianship procedure we've pivoted and done so on the basis of our own legal expertise and view on matters, but also with the input of appropriate medical advice. So it's a difficult, nuanced area of the law that requires sensitivity and requires often attentiveness to circumstances. And I've mentioned that this third bullet, incapacity shall be construed accordingly, but does the legislation really define it? And again, this is quite an academic point, so I don't want to deep dive it too much, but for those of us who've spent an awful lot of time looking at the definition of incapacity in terms of the Adults with Incapacity Act, this incapable means incapable of is a slightly problematic piece of legal framing. So we are defining incapable by use of the word incapable, and I include this piece from the NHS guidance, which I think is perhaps helpful in relation to how we think about these things, and that's the incapacity or capacity is the ability to use and understand information to make a decision and communicate the decision made. So I don't present that as an alternative to the Act, but perhaps to contextualise the Act definition. And why might it be important to understand capacity in relation to planning, in relation to trust planning in particular? Well, it's important for us to understand who our client is and from whom we can take instructions. That may be from the settlor of the trust, it may be from the settlor beneficiary of the trust, it may be from attorneys, and of course, subject to them having the appropriate powers to do so. It may be guardians, and maybe just worth emphasising that point that when trusts are to be settled by guardians, and that's something that we do quite a lot, it's essential that the guardian has that power to settle the trust. For those of you dealing in this area, there can be a great deal of frustration, I think, when you get to the point where a trust really needs to be brought into effect, and you look at the guardianship order and establish that it's not there, and we're going down this route of varying guardianship orders or utilising intervention orders at quite a late stage. It can really drag these things out, as I'm sure will come as no surprise to any of you in this particular area of practice. It's also important when we talk about capacity and indeed vulnerability more widely to understand where further or different measures and different structures are going to be needed for a beneficiary. So a trust will be part, we assume in terms of the conversation that we're having today, that a trust would be part of the infrastructure needed to support people, but it would be relatively rare, I think, that a trust stands alone in doing that. Usually, we're looking at adult incapacity measures in the background. Often, we are considering will planning in relation to same, and then beyond that, there are other issues around pensions and kind of life planning and various other bits and pieces that can come into effect. And that's leaving aside altogether the other areas of professional advice that can be very important for people in these circumstances. And whom should settle a trust, and what are the tax and care and benefits implications? And Callum will come on to this in a little bit more detail later on. But what we're really talking about there is trusts can be settled in any number of ways, and also by different settlers. A common theme in the area of disabled persons trusts is parent settlor for child beneficiary. In personal injury trusts, it's almost always, if not always, settlor beneficiary, same people. And there are tax implications. It doesn't necessarily mean that tax is paid in relation to these things, but there are always tax implications for the settlor of a trust and indeed for the trustees of trusts to take into account. And depending on who has divested themselves of assets, there are implications in relation to care and benefits. And this can sometimes bear a great deal of thinking when it comes to trying to get the structure right for people. And that final bullet, what might the trust work look like? So what are we thinking of, and why does capacity come into that? Well, we have this concept of mixed capacity that I touched on, where a person can have capacity to do one thing and simultaneously lack the capacity to do another. Well, a very good example of that is something that we have experienced in practice, and that is that a person can very well have the capacity to set up a trust and to appoint themselves as a trustee, but they may not have the capacity to be a trustee, to understand that role, and to have an appropriate and to develop an appropriate understanding of the role of the trustee and the legal obligations of a trustee to beneficiaries of a trust, even where that person is the beneficiary themselves. And often mixed capacity beneficiaries of trusts can be the greater drivers of time in relation to trust work. So when we're thinking about whether to engage in trust planning, one of the things that we have to think about is what is the benefit that is going to be created by this trust, and what is the cost, or what are the potential cost implications of the trust itself, and that there can be a tension between the cost of the trust and the benefit to be provided. And then there's the defining roles, often with trusts for significantly vulnerable people, for sometimes profoundly disabled people or seriously injured people. We have, yes, trustees involved with the management of funds, but often there are guardians or attorneys dealing with the day-to-day management of the affairs and support of the adult, or indeed a parent with a child, in relation to the overall infrastructure of that person's lives. So what are the defining roles, and what is the division of labour in relation to that person? We spoke a little bit about capacity. Another area of developing law in the area is around disability. Certainly when it comes to Disabled Persons Trust, which is something that Callum will develop, this definition of disabled, or one of the definitions of disabled, is absolutely central to that planning, and that's the second of those two bullets, the Finance Act. The first of the two bullets tells us that a person has a disability if they have a physical or mental impairment, and so it's a cumulative test. The impairment has a substantial and long-term adverse effect on their ability to carry out normal day-to-day activities. So that's quite wide. The Finance Act 2005 informs the Disabled Persons Trusts legislation within the Inheritance Tax Act 1984. And the definition of a disabled person in terms of that, which is central to a lot of the work that we do, is that a person by reason of mental disorder within the meaning of the Act, of the Mental Health Act, is incapable of administering his or her property or managing their affairs. So that's a little bit more narrow. Or who is in receipt of prescribed benefits. So there are certain benefits. Personal independence payment is one, where there is an automatic qualification as a qualifying disabled person. And I've mentioned at the end there that there is also the United Nations Convention on Rights of Persons with Disabilities to consider when we talk about who qualifies as a disabled person. And I mention that not so much because of its impact on trust planning, but more in relation to its impact around adult incapacity law. As I said, the amendment bill is due to, we think it's due to come to the fore ahead of the summer recess. The UNCRPD is going to be central to that piece of legislation, we understand. And the definition of disabled in relation to that is those who have a long-term physical, mental, intellectual, or sensory impairment that, in interaction with various barriers, may hinder their full and effective participation in society on an equal basis with others. Now, what that adds in is this idea of participation in society. So that, to my mind, seems to be the widest definition yet when it comes to disability. So I suppose the question might be, what might that mean? And not only in relation to adult capacity and support and protection law, but also what that might come to mean in relation to trust planning, for example. So trusts are important when it comes to planning for people with disabilities, and they can be hugely helpful, is our experience. But people's needs, beneficiaries' needs, can be complex, and trusts will rarely answer every question. So when I'm dealing with I spoke recently at the Cerebral Palsy Scotland conference in Glasgow, and one of the kind of central pillars of that talk was around planning not just for the vulnerable person or the disabled person. And with certain illnesses, conditions, it can be something of a sliding scale in terms of capacity and disability, etc. But not just planning for that person, but planning for the family around them. So it's not uncommon for people to come to us and to come with almost the answer of a trust before speaking about their needs, because they hear the term Disabled Persons Trust, they assume that they will have a qualifying beneficiary, and often they will, and they assume that that will be the right answer. But sometimes these families have in place the infrastructure to deal with the financial support and the welfare support of that person already, and sometimes they have that infrastructure over generations. And sometimes our job is simply to say to them, well, do you know what, you might by introducing a lifetime trust, you might be introducing cost where you don't need to do that. You might be introducing compliance weight, which can be quite onerous, where you don't need to do that. And actually the answer may be to make sure that right across the family, suitable powers of attorney are in place to ensure that there can be a transition where generation one is not able to do what they have been doing, and that wills are in place to allow for transition of roles on a death. But in relation to both wills and powers of attorney, those documents allow for the use of trusts when generation one are beyond the point where they can bring that into effect themselves. And that kind of mechanism can be quite helpful in moving the conversation slightly further down the roads, where it doesn't need to be addressed at this point. Now, it will not be every set of circumstances where it doesn't need to be addressed at this point, and there are various reasons why lifetime trust planning to support people it is the right answer. And oftentimes that will be informed by family structure, family profile, risk elements. It can even be informed by inheritance tax planning, albeit that the vast majority of these trusts are administrative in nature rather than tax focused or tax led. As part of that wider planning structure, pensions and life policies, it's not always what people go to. But when a person dies, there can be rights that are derived from other arrangements. And without planning around those other arrangements, we can end up in a scenario where capital comes into the estate of disabled people, injured people, and upsets the planning that was already in place, because a lot of the things that we concern ourselves here with have financial levels to consider in relation to how much capital can be held, income that can potentially disrupt or lead to hiatus in relation to benefits, or can change the profile of care support. Callum's going to come on to trusts more fully in just a moment, and I'm going to shut up for a bit. We seem to be reasonably okay in terms of time. When we talk about trusts at a higher level, and why trusts can be important in relation to planning for people who have been injured, people who are disabled, and people who, for other reasons, are vulnerable. And we touched on that the reasons why a person can be vulnerable far outstrip issues of capacity. And that can be protections for the beneficiary, and often is informed centrally by protections for the beneficiary. Some beneficiaries need that protection more than others. It can be informed by the support and structure for trustees. There's a real, and I think this applies to powers of attorney too, there's a really quite a strong argument when it comes to administrative trusts that supports the idea that having a board of trustees that can stand shoulder to shoulder with each other and sharing the responsibility of supporting a vulnerable person, that can add real value to the people that have that responsibility. It can add value in terms of the support of having people around you. It can add value in terms of having the structure of a legal structure itself, but also the duties and the rigor of trust administration in relation to these things. People can take a great deal of comfort from that. Care benefits and tax, we've spoken about. Callum will speak a little bit more about that. And I popped in this final bullet point: consider the leading nature of the Disabled Persons Trust. It's common for people to come to us, whether it's other professional advisors or clients themselves, prospective clients, with the idea of the Disabled Persons Trust on the tip of their tongue. It's not always the right answer. There are particular tax implications in relation to these trusts. There are limitations in terms of the flexibility that one has as or that trustees have in relation to the administration of a trust. And there can be, if you're not wary, unintended consequences relating in particular to taxation and to property taxation, where expert advice is ordinarily needed. And that expert advice may very well lead away from Disabled Persons Trusts as a structure into something perhaps a little bit more flexible. So with that, I'm going to hand over to Callum. Thank you.
Thanks, Pete. Yeah, so Pete's focused more on the beneficiary themselves and how trusts might fit into wider estate planning. What I'm going to speak about in a bit more detail is the trusts themselves, and particularly vulnerable persons trusts. And the first slide here is looking at the considerations that we have in mind when a client might come to us, and a trust might be something that we're thinking about. There's a real range of considerations, and Pete's touched on quite a few of them already, and it would take a while to go through all of them, but I'm going to focus in on care benefits, and we'll speak about tax in a bit of detail. I'll try not to bore you too much on that. So vulnerable persons trusts, they can be very useful for care and benefits purposes. Often when a client is coming to us and considering putting in place a trust, it will often be for the benefit of somebody who might be in receipt of certain means tested benefits, that they might have care packages in place which are also means tested, and residential care can often be on the horizon as well. So that there's a wish on the part of the client that might be the beneficiary themselves. It might be settlers of the trust who could be parents. There's they don't want to interfere with those entitlements, and often outright gifts might interfere, or outright legacies in terms of wills might interfere. So trusts, they can absolutely help with preserving care and benefits entitlements, but it is quite dependent on how they are set up, and sometimes if there are certain pitfalls, and if they're not set up in the correct way, then there is the risk that there is expense incurred in setting up the trust, but the actual aim of the client isn't achieved at the end of the day. So in that second bullet point, set out various different types of trust, and I'll go through them relatively quickly. Self-settled trust, so a trust that is settled by an individual for the benefit of themselves, generally speaking, won't have the desired effect in terms of securing ongoing entitlements to benefits and care. Got in brackets there with the exception of personal injury trusts, and we'll come on to speak about personal injury trusts later on. They are subject to their own set of rules to some degree, although they are just trusts at the end of the day. They benefit from some particular legislation. Self-settled trust, I mean, if somebody divulges themselves of assets and they're in receipt of certain means tested benefits or means tested care, that is very likely to be viewed as a deliberate deprivation of capital, which I've touched on in terms of the third bullet point, in the eyes of both the DWP for benefits purposes and the local authority who might be assessing entitlements to care and whether somebody should be self-funding for care. For tax purposes, self-settled trusts, they're pretty neutral often for tax purposes. It's generally the case that at the end of the day, tax will generally be charged at the marginal rate of the person who has settled the assets in trust. So it's not, that might not be problematic, because often people who are invulnerable are paying tax at lower rates, but it's not necessarily beneficial either. Will trusts are a bit safer territory, I suppose, in terms of preserving entitlements to care and benefits if they are set up in the right way. It is competent for a testator to put in place a trust for the benefit of somebody that they want to benefit from their estate, and that trust, if it's a disabled person's trust or a normal discretionary trust, it will be held out with that beneficiary's estate for the purpose of benefits and care assessment. Anything passing from the trust to the beneficiary will, at the point of going into the hands of the beneficiary, be taken into account, but that can generally be managed. And then I've mentioned one other point on will trust. Will trust, although safer territory, if a will trust isn't set up properly, and after somebody has died, there is an intention to put in place a trust, which in theory could be done by deed of variation. There is a bit more nuance there. A deed of variation allows the terms of a will to be varied post-death, and it is competent to set up trusts through deeds of variation. the general thinking among the private client profession has been that a deed of variation post-death, which redirects the interests of somebody who would have otherwise received an outright cash sum potentially, if that is redirected to a trust, I think the general thought was that was likely to be a deliberate deprivation of capital. I haven't seen that it's been tested in Scotland, but in the Court of Protection in England, it was tested in the case of LMS. In that case, that there was a man who died, and he had left £170,000 to his granddaughter. She was 21 years old. She had severe autism and didn't have, was judged not to have capacity. She was in receipt of means-tested benefits, and she also had quite a expensive college placement that was paid for by the local authority, and that was also means-tested. So if she received this £170,000, she was going to lose quite a lot. So her mother, who represented her, applied to the Court of Protection to vary the terms of the will in order to place funds into a disabled person's trust. And slightly surprisingly, the Court of Protection actually did allow that variation on the basis that it would be in the best interest of the disabled beneficiary, and most importantly, it would give effect to the testator's intentions, which were for the beneficiary to actually benefit financially if the legacy was paid as the will said it should be paid. Arguably, there wouldn't have really been a financial benefit in the longer term. So that is potentially a helpful decision in the sense that it might be the case that there is scope to settle trusts post-death in certain circumstances, and generally it seems to focus on the intention of the testator. We do have to take some care around it because we don't know how the DWP, who would assess entitlements to means-tested benefits, or the local authority would necessarily have interpreted that it could be that they didn't necessarily agree with the court and could have potentially taken a different view, but that we don't know what happened in that case. That wouldn't have been a public decision. So but potentially not as straightforward as we initially thought, and might be some scope for post-death planning in that regard. Lifetime trust for children, minor children and adult children. Generally speaking, again, competent ways of securing disregards, of securing entitlements to care and benefits. The only sort of caveat there is in terms of tax. Lifetime trust for minor children can be slightly inefficient for tax purposes if the children are under the age of 16 or potentially 18. I don't know that off the top of my head, but the income from the trust will be taxed at the marginal rate of the settler. So they can be slightly inefficient in some circumstances. In terms of the third bullet point, we've really touched on the way that care and benefits are assessed, and it is important to consider the deliberate deprivation rules. Local authorities, they are stretched and sometimes won't act as promptly as they should do in respect of deliberate deprivations, but it doesn't necessarily mean that we should ignore the rules. In terms of other considerations, I suppose Pete's mentioned it already. Trusts for vulnerable people, they are administrative in nature, and they're not tax vehicles, but it's very important to be aware of the tax implications, and I'll come on to that. That there are considerable tax and reporting requirements, and that has to be considered as part of determining whether or not a trust is appropriate. So getting trusts right, how do we do that? Just because an individual qualifies as a disabled person in terms of the relevant legislation, does that mean that disabled person's trust is the right option? And the simple answer to that is no, it doesn't. A disabled person's trust is a particular form of trust. It can take the form of a discretionary trust or an interest in possession trust, where somebody has a right to income and use of trust assets, but not a right to the underlying capital. They are quite restrictive in their nature. the fund has to really be applied for the benefit of the disabled person throughout their life in order to secure preferential tax treatment, which I'll come on to. And if there is an intention to benefit a wider class of beneficiaries, if the settlers perhaps wanted to benefit other people in their family as well, it might be that disabled persons trust isn't the right type of trust. It could also be that a trust itself is not the right way to go, and that comes down to a variety of considerations, and I'll touch on them on the next slide. So in terms of tax, I won't. I'll try and go through this relatively quickly, but in terms of normal discretionary trusts, if we look at those, they are subject to a very particular tax regime known as the relevant property regime. Income and capital gains are taxed at the highest rates. They're subject to very particular inheritance tax rules. Effectively, you can pass up to your nil rate band into the trust, and anything that you pass in above that will be charged to inheritance tax at lifetime rates of 20%. Trustees of discretionary trusts also pay LBTT, so land building transaction tax on property purchases, as we all do, but they also pay the additional dwelling supplement unless the trust is structured in the right way. A vulnerable persons trust, it does receive, I would say, preferential tax treatment compared to that of a normal discretionary trust, and we go through the various taxes, but it's not subject to the same inheritance tax treatment. We're not limited in terms of how much we can pass into a disabled persons trust. You can pass as much as you want in, and there's no ongoing 10-year charges, which there would be with a normal discretionary trust. On death, a disabled persons trust, the value of it is accumulated with the estate of the beneficiary. So there's no, it's not necessarily a tax avoidance mechanism, but it's probably more straightforward from an inheritance tax perspective, and the reporting requirements are less. From an income and capital gains perspective, if nothing is done, the income and gains are taxed at trust rates, although there are opportunities for reclaims. But if a trust is set up for the benefit of a disabled person, an election can be made to have income and gains taxed effectively at the marginal rate of that of the beneficiary, and that can be really beneficial because, as I mentioned previously, beneficiaries of vulnerable persons trusts are often not people who are in receipt of much income. They can have sort of full personal allowances available, and it can mean that at the end of the day, depending on the value of the trust, a lot of the trust income is taxed at lower rates, or it's not taxed at all because it's within the personal allowance. I've mentioned holdover relief and CGT uplift there as well. They're quite technical points. Holdover relief is a relief that's available on transfers of assets into a discretionary trust. So a settler could transfer, let's say, a property into a trust, and that would usually be a chargeable event for capital gains tax purposes. So capital gains tax would be payable. Instead, if there is a wish not to pay capital gains tax at that point, the gain can be held over, which means that the trustees of the discretionary trust would receive the property at the base cost of the transferor. And it's not a means of mitigating capital gains tax, but it is a way of delaying the payment, which can be quite helpful where there are things like property going into trust and there's not necessarily cash being realised, and there is a wish to avoid paying quite a substantial sum in tax at that time. CGT uplift, I've mentioned that as well. Capital gains tax uplift applies on assets owned by somebody on death. So if I own property, effectively capital gains are wiped out on death, and the base cost is uplifted to date of death values. There is now an automatic uplift that's applied to assets within a disabled persons trust. So that's quite good news, I suppose, from the perspective of tax compliance for disabled persons trusts. Finally, in terms of tax, I've mentioned property purchases, and I touched on the fact that discretionary trustees pay LBTT and the additional dwelling supplement on property purchases. That's quite punitive. The additional dwelling supplement is a tax that is sometimes paid by individuals, but it's generally when they own they're buying a second property. And it's recently been raised to a flat rate of 8% of the value of the property itself. Disabled persons trusts, that they don't unfortunately receive any beneficial treatment compared to that of a normal discretionary trust. So the default position is that LBTT and ADS are payable on property purchases. The trust can be structured in a way to try and get around that, and the way to do that is to appoint something called an interest in possession, which I spoke about earlier, which effectively gives the beneficiary a right to reside in and use the property. And if they do that, then if the beneficiary doesn't own any other property, ADS won't be payable. So our ways around it, but it is a potential pitfall, and it's potentially quite a sizable sum that might be payable if the trust isn't set up in the right way. So in terms of actually setting trusts up, when should they happen? When should the trust be settled? It's always circumstance dependent, and as I mentioned previously, sometimes it will be that a trust shouldn't be set up, and that can be the case when an individual might already have a good support network around them, and there's no need to bring the complication of a trust into the picture. If it's decided that a trust is appropriate, then it's a question of should it be a lifetime trust? Should it be in a will? If it's going to be a lifetime trust, it's generally good to get them up and running quickly. And even if there is a good support network, it can make sense to settle a trust during life, because although there might be a good support network in place at that moment in time, that support network is quite often the parents of the beneficiary, and if they're no longer around, it can be beneficial to set up a trust while they are, so that the beneficiary can get used to how a trust operates while they've got their parents there to help them. Cost is mentioned there as well. Cost of setting up and administering it. Trusts are complicated things to administer, and there is a cost to set them up, and I think that always has to be taken into consideration. For example, if somebody wants to make a gift to a child and they're thinking about utilising a disabled person's trust, if that gift is sort of a low value cash sum, and the trust expenses are going to eat into a lot of that, it might not make sense to put in place a trust at that moment in time. Trustees are very important. Trustees are the people who administer the trust funds in accordance with the terms of the trust deed, and there are various statutory duties which must be upheld. In terms of who that might be, sometimes it's a really easy answer. It can be that support network that they've already got in place. It might be parents, it might be sort of siblings, it could be friends and other members of their family. Sometimes it's not as straightforward as that. We've got quite a few quite complex trusts that we administer, and it's beneficiaries that don't necessarily have that support in place, and they might have family that they speak to, but those family members aren't necessarily a good influence on them and aren't appropriate to appoint as trustees. Most private client firms will have a professional trustee company, and it can make sense to bring in a professional trustee where there's not necessarily someone appropriate to appoint. And even where there are an appropriate board of trustees, a professional trustee company has value. It gives sort of proximity to legal advice, and it gives a sort of independent sounding board for the trustees more broadly. In terms of how many, it can be as many as you want. Trustees act by majority in Scotland, so 3 is usually a good number, but it's always led by the circumstances. And what should the trust hold? Again, very much dependent on what the value of the trust is, the needs of the beneficiary, and what the trustees are comfortable with, and tax again is always a consideration. Trusts can effectively hold whatever we could as individuals, subject to certain exceptions. Exceptions. For example, trustees couldn't hold an ISA, but they can hold property, investments, and cash. And the higher value trusts, you'll often see a wide range of assets that are held. The next slide is personal injury trusts, but personal injury trusts it's an area in which Peter and I operate very regularly. PI trusts are and vulnerable persons trusts. They're different concepts, but they're very much intertwined with each other. A personal injury trust, it's not a certain type of trust. It's not a discretionary trust. It's not an interest in possession trust. It's not a bear trust, but it can be any of them. It's defined by what it holds and who it holds that for. And what it has to hold is funds that are derived from a personal injury. So that can be personal injury award funds, but it can also be sort of insurance payouts and crowdfunding and things like that. So within that definition, there is a sort of broad range of sources that funds can come from. The benefit that personal injury trusts have over other types of trusts that are not personal injury trusts are that they're considered disregarded locations for the purpose of assessment for means tested benefits and for residential care. They are also to a lesser degree helpful for where there's non-residential care in place, non-residential care being care at the home. But the protections there aren't quite as comprehensive, but they still have utility. PI trusts, they don't have a separate tax treatment to other types of trusts. They can be vulnerable persons trusts, they can be discretionary trusts, but whatever category of trust that they are, they will be taxed as such. In practice, PI trusts, they're very different. Well, not always. Sometimes they're quite similar in terms of their administration, but sometimes they're very different to the trust that a private client practitioner might usually administer. The money is often needed for different reasons than it might be where a trust is normally being settled. Trusts are with the sort of standard private client, maybe aimed at sort of tax planning and things like that. But these trusts are really there to provide for the beneficiary for the rest of their life, and they really need to be managed carefully, and often the money is needed for things like property purchases at the outset. There's often quite a intense need for cash at the outset as properties are purchased. There can be things like prosthetics that are being purchased, and there's often care and rehabilitation following an injury. And although they can be very sizable sums, the lifespan of these trusts often mirrors the lifespan of the beneficiary themselves. So I've mentioned the lottery winner comparison there, and we have some cases where the administration of the trusts has been more difficult because in the early stages of the trust, the beneficiary has just seen that they've got a few million quid in the bank, and they've spent like money's never going to run out. But care needs can be really comprehensive, and these awards are made, as I'm sure a lot of people on this call will know better than Pete and I, that the money is awarded for certain purposes, and it's intended to last for the remainder of the person's life. And if money is spent irresponsibly, that the trust won't do what the award was set out to achieve. Dealing with injured people can be difficult at times. There's often Pete's touched on capacity, and we're often dealing with people with no capacity or reduced capacity, and there's volatilities and sensitivities around the injury itself. It's often where somebody has reduced capacity but does have capacity that we find that is the most time consuming relationships that we have, because the individual, they have capacity to give us instructions, but they don't necessarily act in their own interest. Whereas if someone has no capacity, that there might be a guardian appointed, and things can be more straightforward. There can be imposed restrictions in terms of PI trusts as well, where a guardian is settled a trust, there might be a requirement to seek the OPG's approval on the terms of the trust deed, or if the Criminal Injuries Compensation Authority has awarded the sum to the beneficiary, that there can be restrictions on who can benefit from the trust and restrictions on who can be a trustee as well. And often the beneficiary themselves is not allowed to be a trustee, which can put some strain on the client relationship at times. Final bullet there is redrawing the lines of the traditional professional relationship. The role of a solicitor with PI trust, it's very broad, and we can often get pulled in directions that we usually wouldn't see ourselves getting pulled. You're almost sort of having to fill the role of a social worker at times, which we're not necessarily qualified to do. So it's very important to get in place an appropriate support network, and that can involve case managers, very often, or pretty much always involves financial advisors, but it's also a case of getting in place the right rehab and therapy for the client. So yeah, it's a lot to consider, and yeah, it is quite important for us to try and stay in our lane where possible, because otherwise it means that these trusts aren't really going to be as economic as they might be as well. So just to finish off, the sort of key planning questions that we might look at. So is a lifetime trust going to help the beneficiary now? That is something that we will generally ask ourselves at the outset, and as I've touched on, it might not be the answer at that moment in time. It might be the case that, as Pete's mentioned, that an appropriately framed will can do the trick, but there are plenty situations where a trust is appropriate. What types of trusts are available for the beneficiary? It depends on the beneficiary themselves. If funds are derived in consequence of a personal injury, then a PI trust is an option, and if a person qualifies as a disabled person in terms of the relevant legislation, then a disabled person's trust is an option as well. But a disabled person's trust isn't always the right answer in itself. And how do I get the structure right? Careful consideration of trustees, and getting the right advice around the trust property. And I mentioned it previously, but getting other professionals such as IFAs on board at the right time often makes our life a lot easier, and is very much in the interest of the beneficiaries themselves. And finally, is the rest of the infrastructure in place, and are the right people in place? Trusts are one piece of the puzzle. That there's so much to setting up a beneficiary in the right way, and making sure that they're provided for. And in terms of the legal work, that's often trusts and its wills and powers of attorney, but there's a much wider picture that we have to consider, and our role is often to try and pull in the right people at the right time, and make things as easy as possible for the beneficiary. So, anything else to add here?
No.
So I think we're quite close to the end there. If there are any questions, you can let us know. And if you don't want to ask anything at the moment, you can feel free to drop us an email after.
Absolutely.
Thank you so much, you two. I really appreciate Calvin and Pete taking the time today.